Welcome everyone back to Land Law. In the last lesson, what we did was talk about the doctrine of notice, and we remember that this is a procedure essentially, which is utilized in the case of the purchase of unregistered land to essentially be able to take priority over potential equitable interests that may exist over that particular property. We noticed as well, pardon the pun, that the doctrine of notice specifically has with it three major elements in terms of the kinds of notice that needs to be given. We noted that these were the concept of actual notice, which we explored in the previous lesson, and then we also said that there were two others. There was constructive notice and imputed notice. In this lesson, we're going to tackle the second of these, which is, of course, constructive notice. We'll talk about what constructive notice means, how it is applied, and look at some of the case law rules that exist in this area. And then we will talk very briefly in the final lesson on this topic, looking at imputed notice. So essentially, we were talking about the different kinds of notice which were applicable in a situation of essentially whether or not an equitable interest is bound to the purchaser of unregistered title. We're going to explore the next kind of notice which can exist in this area in this lesson, talking about this concept of constructive notice. Now, as a very basic and brief recap, let's just explore what actual notice entails very, very quickly. So actual notice is what we looked at in the previous lesson, and it just refers to whether or not the purchaser of an estate was actually given notice of the existence of an equitable interest at the time of which the purchase of the estate takes place. Now, we noted that this is an objective test, so essentially what is considered to be actual notice of a registered of an equitable interest is determined by on the basis of what a reasonable person would describe as an actual notice of an equitable interest. It's not a subjective test, it is an objective test. So that's what actual notice refers to, as the name may suggest, the actual giving of notice to the individual who may be in the process of conveyancing unregistered title. Constructive notice is a little bit different, because constructive notice will be satisfied if the purchaser of the land has made the relevant checks which are necessary during the process of the title conveyance. So, whereas actual notice is, did this person actually get informed of the equitable interest? Constructive notice is, given the amount of money that is being passed over for the purchase of unregistered land, given how legally and logistically complicated it is to purchase land in any format, did the person who is purchasing land make the relevant checks to find out if there was an equitable interest or not? Essentially, the doctrine of constructive notice places a duty on the purchaser to make sure that they have acted in an adequate manner to ensure the two major questions in purchasing title are satisfied. So the first question, of course, is, does the vendor have good title? I.e., does the person who is selling the land have the title that is to actually be able to sell the land? Are they the actual owners of the land? Is the sort of translation from does the vendor have good title? And then the second question is, are there any third-party interests which may bind said purchaser? And these are two duties and burdens which are placed on the purchaser to essentially find out themselves in the process of purchasing, whether it is registered or unregistered title. Constructive notice, therefore, places a burden on the purchaser to act wisely, taking the relevant legal advice in doing so, and they also are acting wisely to ensure that they have the adequate information relating to any potential interest that could exist over the land. Now, one of the interesting cases in this area is the case of Hunt and Look from 1902, and what this does is it gives rise to a specific rule when it comes to the doctrine of constructive notice. Let's just quickly go over quite briefly the facts of this particular case. The facts of this case are as follows. Essentially, there had existed a number of properties which were owned by an individual by the name of Dr. Hunt. Dr. Hunt would have an agent of his to essentially collect the rent on these properties. So we had a number of properties. An agent of his would collect those properties, or at least the rent for those properties. The land was then conveyanced to a Mr. Gilbert. Mr. Gilbert would then go on to mortgage said property. when Dr. Hunt died, the legality of this conveyance was challenged. And so the next question was, given that those acting on behalf of Dr. Hunt were the receivers of rent in the property, they argued that interest existed by way of constructive notice on the part of the mortgagee. And it was held that the doctrine of constructive notice does require that a purchaser will have to make inspections reasonably discoverable by inspection of the property. Okay, and they argued that this does not extend to the rights of the landlord specifically. And so what this essentially means is that the inspection of interest does not extend to those beyond that of the tenant in occupation themselves. This gives rise to the hunt and look rule, which essentially tells us that if a purchaser or a mortgagee has noticed that the vendor or mortgagor is not in possession of the property, he must make inquiries of the person in possession, of the tenant who is in possession, and find out from him what his rights are. And if he does not choose to do that, then whatever title he acquires as a purchaser of mortgagee will be subject to the title or right of the tenant in possession. So essentially, this reasonable inspection of the person who is in occupation of the property is a burden that is still also placed on that of the purchaser of the estate. And if the purchaser of the estate chooses not to do that, then whatever title is acquired as a result will therefore have subject with it the title of the right of the tenant who is in possession of the property.